My name is Dan Gilman. I'm with the International Center for Law and Economics, ICLE, and the main thing I want to do is welcome you here. I'm very glad that you could be here for our panel discussion on the future of antitrust. I want to, first of all, remember to thank Jim, the fellow with the phone, and Emily and Josh for there's Emily, making this actually work so that we have a place to show up and talk and have some things to eat, including really good potato chips. So ICLE is a nonpartisan, not-for-profit research and policy institute. What do? We aim to help build the foundations for sensible, economically grounded policy. ICLE promotes the use of a law and economics framework and economic learning to inform policy debates. And as many of you know, one of our central areas of interest and expertise is that of antitrust. I myself am, as I said in my first post at Truth in the Market, a refugee from the Federal Trade Commission. What are we talking about today? What's the point of our title? I think many of you know that we've, well, I expect you all know we've had a change in administrations. As many of you know, under the prior administration, we had the marketing or billing of a radical change in antitrust goals, antitrust standards. A lot of this was captured in documents that didn't have the force of law, the 2023 merger guidelines, the FTC's Section 5 policy statement, but some of it worked its way into the cases. Some of it worked its way into substance, some of it worked its way into process. I don't think we really saw a radical change in the law or economic methods, but that's something that our learned panel can talk to you about. The question for today is not just backwards looking, what happened, what was and wasn't accomplished, but forward looking, the question on everyone's mind who's interested in competition policy is what's coming next, right? So there was billing of an abandonment of consumer welfare standard, right? There were billing of new goals for antitrust. We had a return to structural standards and a ramping up of structural standards in antitrust. How much of this is going to find its way into the law, I don't really know, but because the purported change was a joint effort, FTC and DOJ are two federal antitrust agencies, we have put together the panel that we have today. I think sort of a rare selection of expertise. And so I'm not going to waste a lot of time. I'm just going to introduce them. I'm not going to read their bios. They have copious accomplishments. We have bios for you. You can find them on the web. It's very easy. But I'll just say, start with the Honorable Maureen Ohlhausen, not just because of her dubious distinction of having hired me, but she is the head of the competition practice at Wilson Sonsini, and as most of you know, formerly acting chairman and commissioner at the Federal Trade Commission. Bill Blumenthal had a long and distinguished career in private practice and is a retired partner of Sidley Austin, but he's also a former FTC General Counsel, served an important position in that regard, and bringing, well, antitrust expertise, but also a DOJ experience perspective is Andrew Finch. He's a partner at Cravath, Swaine & Moore, served on the DOJ Antitrust Division as Principal Deputy Assistant Attorney General, and in fact, Acting Assistant Attorney General for Antitrust, which is to say the head of the DOJ Antitrust Division. So moderating discussion is going to be Geoffrey Manne, the founder and president at ICLE, and many of you know him as an antitrust scholar. So without further ado, I'm going to turn the discussion over to Jeff and our panelists.
Thanks, Dan. Thanks, everyone, for coming. I like to point out that I had one of the most successful career stints at the FTC myself. It lasted 2 weeks, and I consider that to be the highlight of that experience was Joe Sims calling me on a regular basis to ask why his deal hadn't been approved yet. and everyone else was out of the office, so I had to answer the phone. As Dan said, we're at a sort of a period of transition in the antitrust agencies, and we thought who better than people who know those agencies like the back of their hands to help us understand what we just went through and what we're going to experience going forward. I'm sure that no one will hold you to anything you say, but feel free to hedge as you desire. I'm going to jump in. We could jump into any place, but I think that one of the interesting things to start with is to point out, recognize that we had what I think many would consider a pretty politicized antitrust era under the Biden administration, and now we kind of have some signs in the early days of the current administration that politicization is going to continue. That hasn't been, at least not overtly, such a big part of the antitrust sort of firmament in prior years. So I'm curious, first of all, what you think of this development, whether you think indeed we are going to see a continuation of, well, you can also take issue and claim that the last administration was not politicized. But assuming you agree with that, are we going to see more of that? And what do we think the consequences of that are? And I encourage anyone to jump in.
Sure. They're handing the hot potato to me.
Yeah, exactly.
Here. The previous administration, Lena Khan, said it was politicized. She said all of these antitrust decisions are political decisions, right? So I think she embraced that. And antitrust kind of rose up to be this almost like, I wouldn't say it was a household issue for the average person, but certainly you would think it was from the way the press covered it, right? So the press was like super interested, everything that she did. She got incredible name recognition, kind of incredible attention for all of her pronouncements. Did it really result in permanent changes to the antitrust law? You know, she didn't win a lot of cases, as Dan mentioned. Policy statements, things like that, can be swept away easily by the next turn of the political wheel. But one of the things that she did do was, I think, create these expectations that the FTC and DOJ, certainly, but I'll focus more on the FTC, would be kind of active on these issues in a way that got this kind of white-hot attention. So I think one of the things we're seeing is, with the new leadership at the FTC, is kind of taking a page from her playbook and continuing to act in that way. That is for maybe a little bit more of the broader political press attention. I think one of the things that remains to be seen is how this will translate into actual enforcement actions or other types of actions, right? We've seen they've kept the merger guidelines. We can talk about that. They've kept the HSR new rules. We can talk about that separately. But as the signal, and overtly, I think explicitly, as the signal to say we're going to stay aggressive on antitrust. But what is that really going to mean? I think it's still too early. It's still too early to tell.
In the abstract, does anyone defend that sort of approach? I mean, as you pointed out, Maureen, it brought a lot of attention to antitrust. Maybe that's a good thing. I mean, maybe that's looking for a silver lining. But and also maybe it is inherently political. Does anyone want to sort of defend, even if you don't defend specifically the approach of the Biden administration, the idea that there is a kind of more overt political aspect to it?
Yeah, so I'll take on a piece of that. I would distinguish between political in the sense of getting a call from the White House saying this company is an enemy of the state and we need you to go after them. And that has happened. I mean, that was antitrust in the Nixon administration. Not a lot, not often, but there was the ITT instance. That's what led to a statute that's still on the books, the Tunney Act. So it has been known to happen. But I would distinguish that type of politicization from the notion that antitrust is essentially applied I/O, right? I mean, it's walking competition policy, and people will have different judgments as to how you strike that policy balance. And I don't think it's realistic to say that we're going to essentially neutralize all of that and strip all political preferences out of the antitrust algorithm.
Yeah, but part of the question is the rhetoric and like Lena literally making that an important part of it. I mean, I don't know. You want to weigh in on this, especially because we should point out that your agency is not nominally as independent as the FTC.
Right, that's true.
Yeah.
That's true. I mean, I think Bill's distinction is right. That there's at least three ways now, I would say, of politicization. There's the, White House calls and says, do this to an enemy. Obviously, that's problematic. Mm-hmm. Then there is the sort of just the fact that the appointees that run both agencies are in fact political. So they are, and they do have some sense. And then I think there's the politicization that is more the popularization of antitrust enforcement and announcing it in a way that is designed to serve the ruling party's agenda very explicitly. Okay. And the unusual thing that happened at the beginning of the last administration that was indicative of the politicization was the president's order on competition, right? The executive order, and also putting Tim Wu in the White House. Can you imagine if Trump in the first administration had said he's going to have somebody at the White House doing competition policy? There would have been a hue and cry that it's outrageous that the president is interfering with competition policy. Now, at the same time, during that time, we saw a lot more public attention being paid to antitrust. People were concerned about monopolies. People were concerned about consolidation. And so I'm not faulting anybody for saying that that's, was wrong. I'm saying that is what happened. And I don't know whether that third kind of politicization is going to go back into a box and go away.
So I 1 second, let me just make this point, and feel free to pick up on it or make another point. I think a lot of people, and by a lot of people I mean me, fear that the trade-off is between kind of politics and economics. And you suggested that antitrust is applied I/O. Yeah, it should be, but I don't know that it always actually is. So in a way, I wonder the extent to which there is a potential problem, a particular problem with the politicization of antitrust, which is that it should be applied I/O, and the politics may get in the way of the economics. And we're used to thinking of sort of Republican administrations being a little bit more pro-economics than Democratic administrations. Do we think that's true going forward if this administration remains sort of politicized?
So I think it depends on the degree of politicization and the rhetoric surrounding the politicization. I mean, the problem 4 years ago, there were two problems 4 years ago. The first was that it was a pretty severe departure from the mainstream that had been in effect for 4 decades. And the second was the ballyhoo surrounding that, the rhetoric that basically said everything for the last 4 decades was wrong, and we're doing a fundamental reset. I mean, up until then, the rhetoric for the better part of 40 years, certainly for 30 years, had been, okay, there are slight deviations when the party in control changes, but fundamentally, we have a lodestar, and that's what we're all working towards. And yeah, slight deviations, but Tom Leary, when he was a commissioner, had a great speech about the essential consistency of antitrust policy. It was in right around 2000, 2001, something like that. And that laid out what the vision had been for a long time. Part of what we have right now, and part of the reason I don't envy Andrew Ferguson and Gail Slater the task they have before them, relates to U.S. antitrust policy in the international domain. right? I mean, the Europeans for a long, long time had always been, not just the European, I mean, various jurisdictions around the world for a long time had been saying, well, we know it's all political. And it was the US that very hard pushed back on that and said, no, it's not. We all are very largely in agreement. And for the last 4 years, we've had, especially the EC, but others saying, see, we told you so. We always knew it. And you finally admitted it. And getting that back in the bottle, I mean, trying to figure out how to walk back the rhetoric of 4 years ago and say, no, it really is a pretty consistent set of policies that are not highly politicized. That's going to be a real challenge.
You're making my point. I mean, the main reason, perhaps, it's been so consistent is because it's driven by economics, or when it's done well, or when it's done appropriately. I mean, on this in particular, on the international, Maureen's really one of the great exemplars of this. What's your thought about how the U.S. has, for the last 4 years, engaged with the sort of international antitrust community? Has that differed from how you did, and what do you think is going to happen for the next one?
So starting out with sort of looking backwards, I completely agree with Bill. Consistently across administrations for the past, 30 more years, it was antitrust is not industrial policy, it's economics driven, it's consumer welfare, right? If you have other values, that you want to import, that's regulation, right? You don't put that into an antitrust analysis, right? You can have CFIUS, national security, what have you, but antitrust was focused on these things. At least under Khan, and I let you speak more about DOJ, there was this move kind of away from that rhetoric towards more of an industrial policy, but it was the strangest industrial policy I've ever seen, which is let us use European leverage and tools against U.S. companies, right?
So
and
like
so,
an anti.
Right. So I think, I'm sure in other capitals they're probably going, great, like you've acknowledged this, and also, but you're not using industrial policy to protect your own interests. I think one of the really interesting things that we need to see with what happens next is we're hearing, say from Vice President Vance, a real call out against European regulatory approaches and antitrust approaches against U.S. interests. Yeah. But we also have statements in the U.S. of the Chair Ferguson and soon to be head of the Antitrust Division, Gail Slater, of, well, we're going to continue to focus like a particular scrutiny on U.S. tech companies. So it will be interesting to see how they kind of marry those two threads together, because right now they seem to be diverging.
It is at least notable that the first of those threads I don't think existed at all in the last administration. So there is a possibility. I mean, and like you said, we've already sort of seen it with some of the international statements from Vance and others, that there will be a bit of a return to a more advocacy role for the U.S. agencies. But you're right; they'll have a little bit of a needle to thread. Yeah.
To pick up on Maureen's point about the continued focus on tech, I'd just point out that a number of those investigations started in the first Trump administration were carried forward. So there was actually, in some ways, more consistency between those two administrations than people might think. And a lot of the things that occurred during the last administration, like redoing the HSR form, right, the new regulations, that is something that had been recognized for a long time at the FTC and the DOJ that needed to be done. Now, I don't know if one could say there's bipartisan support for exactly the way it was redone in the current format, but that was needed. So there were some things that were done that I think were consistent. On the international front, I think that the idea that the U.S. had been sort of saying it's apolitical or non-political and it's just economics driven was, I think, maybe in some ways a little bit misleading when it was even being said on the world, in the world stage. Because at the end of the day, even in our agencies with the political heads, a decision has to be made that's political about whether to bring an enforcement action in every instance. It's not like a box where the economists, spit out and say you're going to sue or you're not going to sue, right? The cases, the economists have their view, the economics is what it is, but somebody has to make a judgment about whether to put resources into a case and bring it. It's always been that way.
But do you think the rhetoric matters? Okay, go ahead.
Well, just picking up on that, though, I don't think people were saying that it is entirely devoid from public policy considerations. I think what the rhetoric was mainly saying was we're all pretty much aligned on a consumer welfare standard. Not necessarily every case, not necessarily across the board, but we don't have a public interest test. And essentially it was targeting a lot of jurisdictions that say we're going to focus on unions, we're going to focus on labor, we're going to focus on income redistribution effects. And that's what the U.S. was saying, don't be doing that.
I do.
Isn't Ferguson saying he wants to do all of those things? Almost. Focus on labor. I think there's
I would say like labor, more of a recognition that labor as an input.
It's an input.
Yeah,
right? Like that,
A more traditional
because one of the things that we saw in the previous administration was everything that went previous before us was wrong and wrong-headed and whatever. But it wasn't an accurate representation, right, of what actually had been, like, oh, consumer welfare is only about prices. No, it's not. There are quality considerations, there's other considerations. Enforcement, they hadn't done X or Y. Well, that's not true. There had been nascent competitor cases, there had been, like a whole lot of things. So I also think some of what Chair Ferguson might be saying is more accurate depiction of the history of antitrust over the past, decades than what we heard from the previous administration. Even if some of it sounds like some of the rhetoric from the previous administration, I think maybe it's more of a reassertion of a more accurate antitrust history.
So how does that translate into, so for people who might be afraid that there isn't that much daylight between, say, Ferguson and the last administration, how does that, where do you see those differences being meaningful? I don't know. We go ahead.
I'm happy to start with labor. I read Andrew Ferguson's comments about labor enforcement, and again, it's not like the first Trump administration didn't have some labor enforcement matters and begin that tradition. I think doesn't mean that the Trump administration would have brought the case on advances paid to best-selling authors, right? That's sort of the question, right? Was the judgment, do you bring a case because you can and you think you can win and want to advance the law, or is it the right use of government resources?
Okay,
that's a kind of,
distinction.
I think, is going to be a difference, right? There will be
You think it will be a difference?
I do. Because there's obviously a focus on the size of government, right, and the use of resources, and so one could also ask a question like, in the Tapestry Capri case, right? Luxury, affordable handbags was the market definition. Okay, maybe that's worth spending a lot of money, millions of dollars of government resources to stop a merger for affordable luxury handbags, but one could ask oneself whether or not that was a worthwhile use of taxpayer resources.
I can't remember who it is, if it's Carl Shapiro or Doug Melton. Somebody always likes to refer to the luxury yacht market. Like if they're colluding in the luxury yacht market, I don't think
exactly.
we really need
Exactly. And the other thing is on labor, I'll just say, look, the non-compete rule that came out under the prior FTC was obviously massively overbroad. But, should people who are changing the oil at the sort of Jiffy Lubes of the world be covered by non-competes so that they can't go down the street and get a job, or drive for 25 or 100 miles and get a job doing the same thing? That's not crazy to say no. There should not be.
It doesn't mean that Andrew Ferguson and others won't make exactly the point that you're making, that the rulemaking is too broad, but that doesn't mean we shouldn't bring particular enforcement actions in particular cases. And that would be an important distinction, and I think one that I would like to see. But I'm worried a little bit, given the approach to the merger guidelines and the HSR rule, whether we'll see it. And I don't know. I guess what I'm afraid of is there's a lot of symbolism tied up, especially in the merger guidelines, and even in the HSR rules, and very much so in the non-compete rule. Ferguson came up with plenty of reasons why to maintain the merger guidelines. I know that Bill is a proponent of this. A big reason not to is that they were imbued with a massive kind of symbolism, that they were imbued with an approach to antitrust that was embodied by the prior administration. And I would have thought that if this administration wanted to distance itself from some of the strong deviations we've been talking about of the last administration from a more traditional antitrust, an easy way to do that would be repeal those merger guidelines. Even if you think they're fine, get rid of them because they stand for something bigger. And they didn't do that. I mean, they haven't done that and have said that they won't. So am I overthinking it?
Yeah.
I know you think that. Yeah.
Well, I actually applaud their not withdrawing the merger
Really?
guidelines. I do. I think that to Bill's point, and Maureen's made this point, that the tack of antitrust enforcement should not be big zigzags in enforcement. And I don't think it's necessarily a good sign when a new administration comes in and withdraws a whole bunch of things. And when you read, that's first, I just think as a policy matter. Their statements did say, in effect, no guidelines are perfect, they're open to revisions, and there might be things at time when adjustments come. But that merger guidelines process was very transparent. They got a lot of comments, took a lot of comments into account. There are a lot of things in there that are aggressive. When I read them, I thought, this a lot of it reflects what I've seen the lawyers inside the agent, when I was at the Antitrust Division, I've seen them reflect questions they've asked and things they've looked at. So if the goal is to have guidelines that reflect and tell you how the reviewing agency is going to look at your transaction, I don't think they're, way off the mark. Now, one could revisit the presumptions and the change in the structural presumptions and all that.
I have a list of things we can
Okay, well,
Maureen, do you
Yeah.
agree? I mean, or where do you think the merger guidelines went too far and might have justified repealing or rescinding?
So one of the things that is unique about this set of guidelines is it's based on case law, Supreme Court case law, much of it, or almost all of it, 50, 60 years old. And there's a reason for that, which was not discussed in the guidelines, which was the fact that once you had the HSR Act and changes to the antitrust expediting statute, merger analysis moved to the courts of appeal, because you're not going to hold an unconsummated merger together. And it's not an accident that people said there have been no merger cases. Well, there was Phoebe Putney, an FTC case, but it was a consummated merger. So the question is, a lot of that analysis over the years since the HSR Act took place at the Court of Appeals level in the circuits, where a lot of that economic analysis got sort of incorporated. So when you bring a case, when they're going to have to bring a case, it's going to have to be in a circuit, right? So I have some hopes that perhaps that's where, as they put a case together, Andrew Ferguson has talked, about being a law enforcement agency, a case-by-case enforcer. So I think, and you see his choices, like for bureau director, people's litigation experience, it may help, right? That when you say, is this a good case? Is this a case we would win? We have to look where we would bring it. The economics, may come in through that channel. But there are things in like the merger guidelines that, I wish there was more discussion of efficiencies. I wrote something about the mission efficiencies, chapter. And so I think that it will be interesting to see how that's determined. Also, market definition. We saw, I think, a lot of like sort of gerrymandering of markets to try to reach, like a 30% and then get the presumption or that kind of thing. I would hope that for market definition, they would use an economic analysis to define a market and then apply the presumptions, right? Rather than sort of the other way. Let's get a market so that we get the presumption. I don't think that's the right order in which to do it.
I guess I think one of the things this administration came in saying, and I think even Andrew did in his document where when he was auditioning for the job, was promotion of American industry. I think there's certain parts of industry that see the merger guidelines and especially the HSR rules as not being a particularly good signal that we really want to promote, economic growth. So I think there's a big symbolism aspect to it, but I think there actually are some real significant aspects of both, and again, especially the HSR guidelines that are worrisome from at least that perspective. It doesn't mean, obviously they have everyone contains multitudes. They have multiple objectives, and maybe it serves other objectives. But I'm wary of it. I guess I'm worried about what it portends. You're not.
When the guidelines came out, when they first came out in draft, when the final ones came out, my reaction both times was, there are a lot of things in here I don't like, but people can live with these. The guidelines on their face are highly discretionary. They're quite ambiguous, and what you read into them, how you would apply them depends pretty heavily on what your priors are. There's almost nothing algorithmic about them, and
Except those HHI thresholds.
well, the HHI thresholds, but again, the HHI thresholds are first, they're just a presumption; they're not binding, and second, they depend very heavily on market definition, and. My reaction when they came out was the next Republican administration, not knowing what it would be at that time, but the next Republican administration can live with these. They would apply them very, very differently from the way that Jonathan Cantor and Lena Khan would apply them. But you can live with them.
If they apply them so differently, then they aren't conveying any kind of consistency or stability.
Well,
right?
it's
I
not.
agree with
It's
you.
not.
Ultimately, it may not matter that much.
It goes to the question of what guidelines are supposed to be. And you have a number of different types of guidelines. The Baxter 82 guidelines, I think, were the 82 merger guidelines were sort of the high watermark of algorithmic guidelines. That if you had all the facts, you plug them in, you kind of crank the lever, you would get an outcome. There are an awful lot of guidelines that are more in the nature of, hey, here's some things to think about. And these guidelines work reasonably well. The 11 big bold letter principles work reasonably well in saying, hey, here are things to think about. They're the things that any of the private practitioners in this room would typically have been thinking about in any merger for a long time. Now, many of them you would just kind of dispense with in a twinkle of an eye. Right? Typically you weren't going to worry very much about verticals other than for the last few years. But is it a question that you at least ought to think through? Sure. So am I troubled by having that in there?
Okay.
No, I'm not troubled by saying you ought to think about verticals. What I am troubled about would be a proposition that, hey, verticals by and large are problematic. And that's some pretty unfortunate tone
you could read that
in
into
there.
That and coupled with some of the enforcement actions, but of course, Andy was involved in a similar enforcement action, arguably. So,
of course, yeah, you're
so
talking
what
about
do
AT&T Time Warner.
Exactly.
Right.
So let's talk for a minute about vertical actions. There was at least one particularly problematic one in the last administration, I would say, Illumina Grail. There were others. And there's the guidelines, but there's also AT&T Time Warner. What differentiates, if anything, the last administration approach? And you're not on the spot from the prior Trump administration, but assuming there's some continuity between the two, how do you think the agencies are going to approach vertical?
I actually think this is a useful area where the law is evolving, and there is, the cases are establishing additional clarity. And one of the things that's most interesting is how parties are engaging in sort of self-help to try to fix it first in a vertical sense, make some kind of offer, right? Do
Like
something.
Illumina Grail.
And Microsoft Activision,
Yeah,
right?
Microsoft
Well,
Activision.
and frankly, AT&T Time Warner,
Yeah,
right?
good
Because
point.
AT&T
Right.
Time Warner, that was a key fact, was
Right.
the arbitration offer that Time Warner made, and was a brilliant maneuver on their part to do that. And so I think that it's helpful that there are these cases and that some
Yeah.
attention has been paid to the risks of real foreclosure if it can happen, but also how parties can fix it.
I want to continue with verticals, but you raise another really good point I want to just throw into the mix, which is the sort of the approach of the agencies to self-help. I think there was a lot of animosity toward that kind of approach in the last administration, and in fact, there were there were scholars and I think even enforcers who specifically said litigating the fix is is pernicious, and trying to fix it ahead of time is deeply problematic. We're going to insist on reviewing the earlier deal, even though you've changed it. Maybe that's it's important to think about. Sorry, and the reason I'm thinking of this is also because of the approach to settlements in the prior Trump administration, the last administration, and then potentially going forward. Those kinds of things could really be outcome determinative. What do we think is how do we expect the new administration might approach those efforts to sort of resolve potential problems that might differ from the Biden administration?
Well, one of the things that they've said, I think, is they'll go back to considering remedies,
Yeah.
right? And so that was, when you talk about a vertical deal, right, there's not a horizontal divestiture fix, right? So remedies are really, really important. I think one of the things that at least the FTC in the previous administration wanted to argue to courts is assess the deal apart from the remedies, right? Don't look at those. And courts are pragmatic, in my experience. And they weren't really willing to do that, right? And we saw that wasn't just during the Biden administration. The courts are like, well, isn't there a solution here? This solution seems to work to me. So I think that's an important issue that we're seeing a different tone taken here, and I think that makes a lot of sense. And there was this argument that mergers are not pro-competitive and that remedies don't work, and like we had all that rhetoric. I don't think that's accurate. I don't think their presumptions that mergers don't create efficiencies and that remedies don't work, I don't think that was accurate. But that was what they at least said their actions were based on. Right. I think moving forward, it seems that we're kind of going back to the idea that, a remedy that can allow the benefits of the deal to go forward and take care of the anti-competitive aspects and mitigate those should be considered. I think it's in some ways forced upon them, but I think it will be. But I think, I know for something, I won't say what deal or whatever, but instructions to staff to not engage on remedies, right? Do not engage on remedy. I don't think we'll see that now, right? Okay. I think that we'll have those discussions happening, because if you want to win cases, you can't go in and ignore an obvious remedy, because the court will reach out.
And do we think that could translate into some of the pending cases being resolved in a way that they probably wouldn't have been resolved in the last administration?
I don't know enough about current pending cases to be able to select the ones that are
I don't think there are that many pending merger cases.
Well,
thinking
in particular of the tech cases. I think we need to talk a little bit about tech, because there is another area where this administration is maybe of two minds. It's inherited a couple of cases. Some of them, as you point out, actually started in the prior Trump administration. I wouldn't say those cases are going great. I mean, Manne is a great example of one that's just, they get smacked down at every turn. At some point, shouldn't you be talking about settlement or something? I don't think the last administration was willing to have that kind of conversation. Maybe this administration would be willing to, or even potentially dropping the cases, which, by the way, I think is another fascinating question that Maureen has some history with, in terms of whether it's sort of possible, whether it's done, whether it's possible. I mean, could they actually literally say, you know what, we don't want, I mean, they can, of course, but would they say, we don't think this is a good case anymore, if they actually thought that?
Well, I mean, Bill Baxter did.
Yeah,
right.
He's sort of the one obvious example.
Right. I mean, on one and the same day, for those who weren't around in this, 45 years ago, he dismissed the IBM case and he announced the settlement of the AT&T case. Right. And if you inherit what you think is a bad case, you may well just dismiss it.
I don't think it's quite that simple, right, Maureen? I mean,
Well, I mean, at the FTC, you need a majority to, like,
So
it's been
that's-
voted out.
that's
So if
part
you're
of
talking about the Qualcomm case, for example, got voted out at the end of the Obama administration, and I dissented, but as acting chair, I couldn't do anything about it because I didn't have a majority, right?
And then you didn't have a quorum, right?
And I had a quorum.
Even with two?
Yeah, it's a
Okay.
quorum with two. We brought a whole lot of cases. I hope we had a
Yeah,
quorum.
no, that's true. No, that's a good point.
Yeah, but I couldn't bring it back.
Okay.
You know, fortunately, Ninth Circuit took care of it for me eventually. But that is a question until.
But would you have?
Would I
mean,
have?
That's a
Well-
weird, I mean, you don't have to answer that question exactly, but,
I mean,
but
I
it would have
would-
seemed like a thing to do, right?
Well, one of the factors, so as the head of an agency that you have to deal with is resources, allocating resources, right? So these things are not costless. They take up staff time, they take up money for experts, even mundane things like the cost of all the transcripts and court reporting and all that stuff. And so I think that's a decision that an agency head has to make. Draft of all, is it a good case or not a good case? Or is it on the bubble or is it not on the bubble, right? Those are kind of questions. Also, the resource drain from those, is it impacting the head, the chair, or the head of the DOJ Antitrust Division's ability to move on their own priorities? Right? Is everything already sort of been pre-committed by the previous administration, and you're kind of like, you know, trying to put together something with chewing gum and something, you know.
You know, one of the things that happens when you vote out a case, or if your AAG authorize a case, is you're doing it based on fact memos where you think you know the facts. I mean, you have certain factual predicates on which the case rests. And as the case progresses in the courts, things change. You know, witnesses change their story, new witnesses come forward. It turns out that the initial interviews weren't quite right. I mean, the place I most saw this was in Rambus, where, you know, Tim Muris to this day says if he had understood what the facts were really going to turn out to be in the Rambus case, he would not have authorized that case. He would not have advocated bringing that case. The facts ended up completely different from what the basis for the case was. And again, IBM's another good example, and there probably are a number of those examples in the tech sector.
Yeah, I mean, one thing that I think is a little bit different about IBM and the cases that are pending now is, again, we had this. You didn't have a kind of. I don't mean this to be pejorative. I mean, I do, but I don't really think you have to be pejorative to say a kind of aberrant administration with the last administration. So the idea of it's one thing to, you know, say, look, this IBM case has been going on for 25 years or something. It's time to pull up stakes, but we gave it a good shot. It's another thing to say we inherited a case that was brought, or cases that were brought by people with a kind of really aberrant attitude toward antitrust from ours. It's almost like I mean, Maureen, you're making a very important practical point, but again, I think there's a kind of a level of symbolism which maybe we wish it weren't part of antitrust anymore. But as we've said, it's sort of been made part of antitrust. I don't know. I mean, you're almost lending your imprimatur to something that you may find was motivated by something deeply problematic. If you don't
Can I,
withdraw or somehow respond.
I'd just go back and say, I mean, it's not. It would be shocking if the new agency heads don't look at whether there are ways to resolve cases and, you know, merger cases or the pending conduct cases in a way that will free up resources and let them do their thing. And, you know, the Bush administration settled the Microsoft cases, so it's not going to be
The other
surprising.
example.
But, you know, continuing with some of these cases, just because they were actually filed during the last administration, I don't think is the
That doesn't
necessarily
make
the
sense.
reason
That-
to do it.
okay.
And some of them, like I said, were investigations that began
Right.
earlier.
yeah, let me address the tech cases. I mean, the fact that we disagree with a lot of what the prior administration did doesn't mean that we think, at least in my case, doesn't mean that I think that everything they did was wrong. You know, Andrew already alluded to, you know, non-competes, right? I mean, overbroad, massively overbroad, but they were kind of sort of onto something. And on the consumer protection side, I would say the same thing. And I would say that in the tech sector as well. And I've been saying as much since 2017. I mean, there was a symposium at GW in early 2017. It was essentially being held to talk about whether consumer welfare is the right standard. And Bill Kovacic brought together a lot of former senior agency folks, essentially to stand up and talk about big tech, consumer welfare. 2 panels of 5. I was on the second panel, and I remember saying, this priesthood is talking to itself too much, and not mindful of what's going on out there. That you have a number of companies that didn't even exist 30 years ago, in some cases 20 years ago, that have ballooned into massive size with significant consequences for small business, significant consequences for business, for consumers. There are tremendous efficiencies, but there are also tremendous consequences. And at least at the time, saying that the best the Obama administration, which has just ended, the best the Obama administration can do is a monopolization case involving hospitals in Michigan and physician networks in Texas. And one of the other panelists at the far end said, "Hey, Bill, that's not fair. You're forgetting the case about slots in Newark." And I said, there we have it. That's not to say that I think that interventions are clearly indicated along the lines that the current administration, the last administration has been doing. But it is to say that we have a limited set of companies that have tremendous effects on the economy, tremendous force these days, with effects good and bad. And it seems to me it's not unreasonable to say that as a matter of public policy, people ought to be thinking about what the limits are and where the lines ought to be drawn and what is permitted and is not permitted. Now that's a different framework from what we saw over the last 4 years, but it does not seem to me to be to be an unreasonable proposition.
Okay.
In fact, I would go further. I mean, to me, it's the single most important question right now in antitrust at the federal level.
I mean, one implication of this is again, I keep talking about sort of symbolism. Not withdrawing those cases is not necessarily a sign that the new administration supports the approach of the prior administration, but perhaps a sign that they think there is something here. I mean, this is why I would hope that we would see the cases evolve. There'd be talks, the kinds of talks that I understand were largely unavailing in the last administration. You can still. The last administration seemed to think the only way to win a case was to literally win the case in court. And I would hope that there's a sense that you can get remedies that really address what you see as potential, as being the problems without having to actually litigate to the end.
One more really important thing to say about tech is I think it's a mistake to say it's tech, it's big tech, we're going to lump 7 of them together. Because the issues are very, very different issues.
Absolutely.
And without going into specifics, I mean, my view is that some of them are better cases than others. Some of them are pretty awful cases.
Indeed.
I would actually I understand why you're saying tech is the most important issue because it drives the most talking head debate stuff. But I think for the average American, it's going to be food prices and it's going to be healthcare prices, right? And the FTC spent many, many years focusing on a lot of those issues, and I hope that it would recalibrate back to some of those things because I think tech draws a lot of attention because of the press and the impact that these companies have had on the funding sources for the press. So there's a whole ecosystem that swirls all around all this tech stuff. But when you see sort of what were the issues that drove, the successful campaign by President Trump this time around, we talk a lot about tech, but I think there are a lot of other issues that actually drove the average voter who voted for Trump that are not captured in the more Washington antitrust circles debate.
I'm being told that we're supposed to open the floor to questions from the floor, and while that's happening, I'm going to ask one other question. So, I don't know if you, Jim, you want to find people that, as you walk over there, you remind me of something, Maureen, that I think we should raise, at least for the FTC folks, but I think even for Andy. Ferguson and Vance and others have made this, the sort of censorship stuff a big part of their campaign, and think that, in fact, even opened investigation, right? Is that really, like, is there really any basis for that to proceed under the antitrust laws, but even perhaps under the FTC Act?
I mean, I think that's what they're asking, right?
Okay, fine to ask
Right.
the question.
Yeah.
But I think they
My short answer on that is I don't think there is an antitrust basis
Right.
for unilateral conduct. To the extent there was essentially standard setting and coordinated conduct, there may be. Maybe worth looking at least. And there may be a consumer protection theory to the extent there were express representations about how we're going to handle your inputs.
I mean, they're not. The express representations are, we get to do what we want. So, I mean,
Yeah.
Unfortunately, there could have been, but I just don't think that's really how the terms of service work. You have any thoughts, Andy, or you want to?
The only thing I'd say, in addition to what Bill just said, is there may be First Amendment overlays that
Oh, yeah.
affect the Sherman Act, the viability of a Sherman Act claim, right?
Totally.
If this is actually political speech or editorial type speech, then that might stand in the way of those cases.
Yeah, right. So, where's Jim? Oh, okay.
Labor. I was reading yesterday the February 2025 USTR, a memorandum from the president on labor, and it was a big emphasis that bad U.S. policy has reduced the number of industrial jobs, the number of jobs, which was high-paying jobs. So they said it will be a paramount goal of the president's to increase the number of those jobs and the size, and relatively speaking, of the industrial sector. So jobs for industrial workers, better paying jobs. You've obviously heard the president say a lot along those lines. So it seems to me, in terms of mergers, certainly in industrial areas, wouldn't you think that it would be sort of paramount importance for companies in potentially merging companies to frame things in a way that, first of all, we're not going to destroy any jobs. Second of all, this is going to create benefits, which is going to allow us to expand Plant X, create more jobs. We can make local community things. We can make
Okay.
guarantees.
Let's stop the question
Thoughts?
there and let them respond. Yeah. Thoughts?
So I didn't respond earlier when we were talking about labor markets, but I did make a note to myself that I've always thought that the best litmus test for how you think about labor in the under the antitrust laws and how the antitrust laws ought to respond to labor considerations is the hypothetical, okay, you have a board memorandum, the basis for this merger is we're going to lay off 10,000 workers and reduce our cost, and we're going to pass that cost reduction on to the consumer, or onto the buyers. Good or bad? Up until fairly recently, that was almost unambiguously good. For the last 4 years, it became highly suspect, maybe bad, in part because we don't credit efficiencies or don't even think efficiencies are good. I think it's kind of open to say where they're really going to take it, but my betting would be notwithstanding that rhetoric, significant efficiencies are going to matter more than some job losses. But they are in tension.
Yep.
Yep. I would say, I think regulatory and political decisions far outside of antitrust have a much bigger impact on that kind of thing. Like, so it's trade. It's really trade issues. We talk about NAFTA, things like that. So, yes, I think occasionally you might have a merger where something is as stark as what Bill said, but I think that's pretty small compared to labor in the previous. When we talk about the tapestry, the complaint included a thing that people who worked in the retail stores selling accessible, affordable luxury handbags somehow are going to be negatively impacted by this merger because they couldn't go sell luxury sweaters or luxury, something like it. Just
Or
was
non-accessible luxury.
or non-accessible, right?
You can't be a seller.
But anyway, so I just, like, theoretically, yes, this is intention, but I just think it was handled in such a different way in the previous administration. I don't think we'll see that type of handling in this administration. And, I think ultimately, if it's going to go to court, I don't necessarily see a judge saying, oh yeah, we're going to throw out efficiencies and things like that.
I do think that the symbolism thing rears its ugly head again. I mean, imagine someone who said the things that Ferguson has said. How is he going to respond when he approves a merger that is clearly going to lay off 10,000 workers? I think it would be hard. I think the politicization of it has made it harder for him. I know this is an extreme case, and there would probably be examples where you wouldn't be held to account. But in the example that Bill gave, I think he's made it hard for him to approve that merger. Okay.
Hi there. Yeah, and I came in a little bit late, so if you all address this on the front end, I do apologize. President Trump has attempted to gain much larger or greater control over independent agencies like the FTC, like FCC. That's kind of one of the pushes that he's trying to do. At the same time, you have individuals like Elon Musk and David Sachs and other folks from the tech sector who are clearly very influential within the administration. And I'm just curious if that aspect gives you any concern. You can talk about it from an antitrust lens or elsewise. When it comes to antitrust matters for, say, the tech sector, for Silicon Valley, is there any concern that that kind of push may result in these kinds of decisions being carried out on a more political basis?
I don't think so. I don't think that that's going to happen. I mean, the first administration, the first Trump administration, I didn't see any of that. Like interfering in individual cases against particular companies, notwithstanding what people have said or thought about the AT&T Time Warner case. I saw none of that. And so I don't think that's going to change. I mean, I expect that to be very similar. And I think that the Attorney General Bondi won't, views it the same way. And I think her Senate testimony sort of confirmed that.
Do you think that given this greater focus on antitrust, it's going to continue the incentive to have less transparency about the resolution of cases? I'm thinking about sort of the ghost settlement phenomenon that people were concerned about at DOJ, and that I think we were also seeing at the end of last year at the FTC as well. There was like a merger that the companies have said, and they're kind of like I think it was the convenience store press were covering that that this deal had happened, that they had to do a divestiture, but they're saying, oh no, we don't have like a case with the FTC. The FTC just said they wanted to see us sell these stores. And that kind of phenomenon, I think, is at least somewhat driven by the greater interest in antitrust, the elimination of early terminations, where people were, you would know whether this deal had been allowed by the FTC without a harder look, et cetera. So that's kind of the concern I see. I mean, in many ways, I think it's great that there's more interest in antitrust, but I worry about the extent to which it actually drives more underground.
I have a view about this, and I've said this before, that I think that those kinds of settlements, the ghost settlements, should go through the Tuniac process. And the Tuniac process exists for a reason, and it should be followed. And so if somebody brings to the Justice Department a settlement, and the Justice Department kicks the tires and thinks it's fine, it ought to go through the Tuniac process for exactly the reason you mentioned, just the transparency of it. Right, and I do hope we see more of that and less of the what we may have been seeing at the end of the last administration. It also gives the government some ability to follow up if the remedy, the self-imposed remedy, doesn't go the way the parties or the government thinks it might go, right? And I think that that's also important.
I agree, and one of the things I actually, back when I was a minority commissioner, I actually had, I believe it was a statement, just talking about the importance of having an enforceable settlement. right? Because if things don't go as promised or expected, what do you have to enforce?
You have a
Nothing,
remedy.
right? It's like, oh, hey, you said something to me, informally. There's nothing the government can do to enforce that.
Is the fear a fear of rent extraction essentially? Like it's a cheap.
Yeah.
I mean, which I don't think is very much addressed.
So that's what I was about to jump in and say, that there's a separate issue, which, Pallavi, I think is the one you're getting at, which is sort of the extortionate nature of the demand. And we're going to extort something. We're just going to keep very quiet about it. We're going to keep it off the books. It's not necessarily essential for the competition bona fides in the hypothetical, if I'm hearing it right. And I think I know some of the cases to which you're referring, and that is a problem. Although having a Tunney Act type of
helps
disclosure
has to help a little bit.
helps quite a bit in kind of forcing it out.
I don't know. I mean,
Helps some.
I guess I think it helps. It helps a little bit, but I suspect that most of these have a superficial, complete sort of plausibility to them, such that it doesn't. I mean, no one really looks at it and sees. I mean, obviously, interested parties might get involved in the Tunney Act proceeding, but I don't know that a judge would really do anything about it anyway.
Yeah, and of course
if the point is the sunshine is the best disinfectant. I'm not sure how much sunshine or how much disinfecting sunshine can do.
Of course, Tunney is limited to DOJ, so the
Right.
FTC,
Right.
to the extent the problem is at the FTC, and some of them have been.
Yeah, and it can depend a lot on the
I thought it
judge.
was a DOJ
Right.
problem.
Well,
Well, because
I don't
I
think we
also
can
think
try.
there was this idea that, this purist idea, we're not going to do settlements, right? It's
Well, yeah,
not, right? And then this big focus on the numbers, right? And we saw some kind of reinterpretation of numbers and things like that. So I see it all of kind of a piece of the purist, kind of thing, winning out over transparency.
That's a good point. And I guess I'm being told that we have to end. I mean, y'all are welcome to stay for a while and we can chat, but I suppose we should let people go who need to go. Thanks everyone for coming. Thanks to the panelists.
Well done.
See you around.